going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. This is Judge Shackleford, and I am having a difficult time trying to decide if this is a sovereign citizen or just a try-hard Google attorney. Now, when I say Google attorney, just a defendant that spends a lot of time on Google and finds arguments that sound a lot like SovCit arguments. So let me know. But anyways, this is a civil case in front of Judge Shackleford. So before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Mr. Chavez, do you have audio?
Yes, I'm here.
There we go. All right, this is 23013058 JP Morgan Chase Bank versus Arnold Chavez. Can I get your appearance, counsel?
Yes, Your Honor. Christopher Royce, P49102 on behalf of the plaintiff.
All right, and Mr. Arnold, can you tell me your name?
Yeah, Chavez Arnold.
All right, so today's the time and date set for the settlement conference. Have the parties had any discussions?
Go ahead. No, I'll let you know. No, I guess I thought I was here on Mr. Arnold's motion. I'm trying to see if there have been any calls regarding settlement. Bottom line, it's not settled, but it appears calls have been made for settlement, but nothing is accomplished.
All right, well, I received the motion and denied it.
Okay.
So we're here for a settlement conference. Do the two of you want a breakout room?
So you denied the interrogatories, but I still had other requests through discovery that was never responded to. I never really talked to anyone. I called someone earlier this month, and they said that they were going to get me some of the document that I asked for, and I never received a call or anything.
What is the document that you're looking for?
It is whenever account is open, there's usually a note that evidences the opening of the account. So I wanted to get that for inspection.
Your Honor, if I may, I think that most of the discovery requests were involved in or related to a purchase of a debt, but JP Morgan Chase is the original creditor. We did provide him with the account statements. So there are other documents related to a purchaser, a bill of sale that just don't apply here, Your Honor.
And I would dispute that you guys were the creditor in this transaction.
I mean, how are you going to dispute that?
Through the law.
What is it? I don't understand, sir, what the dispute is.
So the dispute
what are you
is
trying to dispute?
12 U.S. Code subsection 83 or subsection 24(7). It goes through the powers and duties of banks, and they can't loan their own money. They can't loan their reserves. They can't loan their their capital stock, and they only can make loans off of personal security. So I want to see whose personal security was loaned.
No.
All right. So that right there is why I put sovereign citizen in the title. First, he's using U.S. law and not Michigan law. I mean, it is about debts and banks, so maybe that makes sense. I don't know. Yeah, but here's the thing. If that were true, if what he just said would work, everyone that has any debt would use that and get it wiped away. Just saying.
Oh, no.
Yes.
Denied. No,
Well,
denied.
is this on the record?
No, sir. no,
Is this on the record?
sir, your motion is denied. It is, and you can get a copy of the transcript. Okay, it's denied. This is the bank. This isn't the purchase of a loan. This hasn't gone through 15, different companies to collect this money. The original creditor is JP Morgan Chase. And
So
they
are you-
allege that you had a card with them and that you made purchases and that you have an unpaid balance, that you've not paid it off in the amount of $3,398.36. That's where.
Is this on the record, Your Honor? Because all I'm asking is.
Everything is on the record, sir.
Okay. And one more thing. So when I motion for you, I motion you denied for the and for the request for admissions. That was the only thing. I'm entitled to inspect the document that opened it up the account. That's my right.
Did he have something he signed originally, Mr.
Your
Royce,
Honor.
when he?
Let me see if this was, I will see if there was an application, I'm sorry. Yeah, we have the application. I can email it to him.
All right,
Right.
you can see the application, Mr. Arnold.
Right. I want to ask you something. So basically, can I ask him a couple questions?
No, you want to go in a breakout room and talk with him?
Yeah, sure.
All right, Mr. Royce, I'm going to put the two of you in a breakout room so you can discuss this matter.
Okay, thank you.
Thank you. Do I have everyone here in Colin's Asset Group versus Danielle Frick? Mr. Arnold and JP Morgan Chase, did the two of you have some discussions?
Yes, we did, Your Honor.
Okay, and anything fruitful?
No, Your Honor. I believe that Mr. Arnold wants to take a deposition of an accountant for Chase Bank to seek accounting evidence that his account was actually opened.
Do you have no? We're
Listen,
We're not doing that, Mr. Arnold. We are not doing that.
What do you
He will
mean?
provide you with. I am denying the request for depositions.
Why was my whole discovery denied? Like you said, I can get discovery. You said you denied my request for admissions, and I don't have anything. I didn't get no integrity. I didn't get any answer or anything from them.
I
didn't get a call. I didn't get a letter. I didn't get nothing that I asked for. So how are we having a case? How are we talking about anything if I haven't even had a chance to speak?
Mr. Royce, do you have the application where you allege that Mr. Arnold took out that debt?
Yes, Your Honor.
All right, and did you provide that to him?
Yeah, I confirmed his email address, and I'm going to be emailing it to him immediately after the hearing. And I will say that there are some interrogatories that are overdue. I mean, I don't know how they pertain to the case, but I will answer them within 10 days. I think at this point, Your Honor, I think that I know it's, I would just like a date for a motion for summary judgment.
Okay. All right, so he's going to answer the remainder of the interrogatories within 10 days.
Okay.
Did you get an email?
Just a second.
Why does the judge and the attorney keep saying interrogatories? The defendant clearly said integrities. Come on, Judge. You're mispronouncing the word.
Did you give him an email to provide those to you?
Actually, yeah, I have them. I got his email, so I'm going to email him the application immediately after the hearing, so he'll have my contact information with my extension and all that.
Okay.
Yeah, I sent all these things back in August.
Well, I don't know what the questions are. They need to be answered.
And I don't even think that is fair
And
that
or
you
objections
didn't
need to
know.
be filed.
Pardon me?
I said, or objections need to be filed. If he's objecting to them, we'll deal with it that way.
All right. And I just wanted to say, I didn't think it was fair that, you didn't even know what was going on and you just basically said no, this and that. And I'm not even having the opportunity to be heard.
You are having the opportunity to be heard.
I
But
submitted discoveries outside of motions for admissions. You denied the motions for admissions. That's fine.
correct.
I submitted a discovery outside of that and you're still saying no, nothing. You didn't even ask to see if they answered it. Like, that's a little biased, but okay.
It's not, sir.
Okay.
This is a district court. I don't have to grant any discovery. I have discretion on discovery, and discovery is not to be abused.
I'm not
That's just
abusing.
how it works. That's
I
just
asked-
how it works.
I got you.
I say no discovery, but
But
I've
you-
allowed interrogatories, and
Right,
you're to have answers within 10 days.
Right. You allowed it back in August. So you're telling me you didn't have to do it, but you did it. So like, how are we talking about this? All I said is I submitted them and I never received anything back. That's all I said. And
All
they
right.
were yelling.
Were you provided any documents?
Not at all. I didn't receive a response. I called them even afterwards and they said they were working on it and they'll have it for me within a week or so before the settlement. I was told that I would have it.
All right. I actually understand what he's saying here. And now, if this is true, we don't know. I don't have the August hearing, but if Judge Shackleford granted the discoveries back in August and he filed the motions to compel discovery and then she denied it, I understand why he's frustrated. That doesn't really make sense. But I know if she granted discovery, he sent the request to the defendant or the plaintiff in this matter, and they didn't respond, and now he's just trying to say that. I think that's what happened. And okay, let's just keep going. You know what? We'll play it out. Thank you for watching. Hit the like button if you haven't already. Until next time, bye.
All right, 1 second. Hey, Ms. Maudlin, can we have a date in just a few weeks out?
Yeah. Yeah, go.
Let's see. Well, you're here. You are here next Thursday, but we're gonna do one more time. In November.
2 weeks, and maybe 2 weeks out or 3.
It's going on.
All right, I'm gonna give you a new date after you've had a chance to receive all that discovery.
Appreciate it. Thank you.
We can do this Thursday, November 7th. Or 10 a.m.
What's that?
I would say like
On
8:45 or
7th.
9 on November 7th.
All right, we'll return on November 7th at 8:45 a.m. for our final settlement conference. And if there's not a resolution at that date, we'll wait. You want to go out a little further, Mr. Royce, so that you can file your motion?
Yes, Your Honor.
All right. I need 28 days at a minimum.
Oh,
So
okay.
we'll have to go out till later in November.
About no Thursday, November 21st.
All right, 11:21 at, can I just do anytime that morning? 9 a.m.
Yes.
All right, November 21st at 9 a.m. we'll return.
Okay. Thank you, Your Honor.
Thank you. All
Have a
right, we'll
great
see
day.
you back on that day. Mr. Arnold, you'll be back in court on that day. He'll have all your answers to you within 10 days because I've ordered it.
Okay. Thank you. Appreciate it, Your Honor.
Thanks.
All right, thank you.